Have you ever felt uncertain about whether you're experiencing a potential religious freedom violation, or have you ever been unclear about what to do next? Well, today's session, Religious Freedom Violations, What Are They, How to Report Them, is designed for all of us to learn how to identify religious freedom violations and to learn one of the next steps that you can take to address them. And I want to introduce today's presenter, who is Ian Smith. He is our staff attorney for Americans United. Ian handles legal intake of new church-state separation complaints and pursues non-litigation advocacy to attempt to resolve violations without the need for lawsuits. And so we're delighted that Ian has taken time with all the busy work that he does in the legal department to be with us, to talk to us about religious freedom violations and what we can do. So Ian, I'm turning it over to you.
Okay, thank you, Sabrina and David. Thank you, everyone, for coming. I have been at AU for 13 years now, so I've been sort of doing this for a while. I'm going to talk a little bit today about what the Constitution has to say about religious liberty and your religious rights, and how those religious rights can be violated. Because I've been doing this long enough, part of my job is to try and help educate people that are not lawyers about this sort of thing. So hopefully I'll be able to keep it straightforward enough for people to follow. But part of the thing about being a lawyer, having done this for so long, is that there are things that I think are obvious that will sound to me like they're obvious, but that may not be obvious at all. So if I say something that sounds like it is in a foreign language that you don't understand, please, put it in the chat or raise your hand or something and ask me to clarify, because it's very easy for me to zoom past things without necessarily thinking about them, because I'm so familiar with the topic. But I'm really looking forward to talking to people. I know we've got some seminarians here today, as well as AU activists and other things. So I'm going to bias the talk a little bit towards issues with the Free Exercise Clause and how the Free Exercise Clause works, even though AU's work often is more focused on the Establishment Clause, that is to say, the separation of church and state. But we'll get to both. And what we'll be talking about is sort of the basic way that the law works in these areas and how it can be violated, how your rights can be violated. So we start with, what does the Constitution have to say about religious freedom and religious issues? So the first thing that it has to say is in the body of the Constitution proper, before we get to any of the Bill of Rights or any of the amendments. And I'm gonna put the text of this in the chat so you all can follow along. Apparently it auto-muted me whenever I put something in the chat. So, okay, so this is from Article 6, Section 3 of the Constitution. And it says that no religious test shall ever be required as qualification to any office or public trust under the United States. All that means is that you cannot be prevented from holding a governmental position or elected office because of your religion or lack thereof, right? There are actually still some state constitutions that have provisions that say otherwise, but because of some things that we'll talk about as we go along, those provisions are no longer functional, right? Some of them are still in the books. Technically, Tennessee is one. Tennessee actually prohibits atheists from holding any public office, but it's not enforceable, right? Like if the state were ever to actually try and enforce that, it would be struck down as unconstitutional. So that is the first thing that the Constitution has to say about religion. So the second thing is the religious content in the First Amendment, which if I have here, oops. So this is the text of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In the law, we separate this into what we call two clauses. The first clause, Congress shall make no law respecting an establishment of religion, we call the Establishment Clause. And the second, Congress shall make no law prohibiting the free exercise thereof, is the Free Exercise Clause. Together, these provide the protections for religious freedom in this country. Now, as you can see, there's really not a lot there, right? I mean, that's a pretty simple statement upon which we have built like a really complicated bedrock of laws, rules, and regulations and procedures and other things like that. So it's not like constitutional law is not like black letter law. There's a lot of interpretation that goes on, and it can change. Like the Supreme Court released a decision that impacts the Free Exercise Clause last week, right? So these things are sort of in flux, but what I'm going to give you is sort of the basics of how all this works. Now, those of you that are reading carefully may have noticed that this says Congress shall make no law. So that's a lot of times what you will hear people say is something along the lines of the First Amendment doesn't separate church and state because it only applies to the federal government, right? You'll hear people say this, right? It says Congress shall make no law. So why should my state have to, not endorse religion or whatever? I'm going to explain why that is, right? So, and it has to do with the 14th Amendment. Now, the 14th Amendment was put into the Constitution after the Civil War. And here's its text. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So this was written in order to make the national prohibitions against slavery applicable to the states. The entire Bill of Rights, when the Constitution was originally ratified, only applied to the federal government, right? So like states could and did create their own official religions for the state. And the prohibition in the national Constitution didn't apply to them. That changed with the adoption of the 14th Amendment. So in the law, we call what we're doing here, we call it incorporation. So the 14th Amendment, you see here, there's two sections. The state shall not deprive any person without due process of law or deny them equal protection of the laws. So we call those the due process clause of the 14th Amendment and the equal protection clause of the 14th Amendment. So there's something called incorporation, where we use the 14th Amendment to incorporate the protections in the Bill of Rights and the Constitution that originally only applied to the federal government, and now we apply them to the states. And we do, and in the case of the Free Exercise and Establishment Clause, this was done through the 14th Amendment's Due Process Clause. And the idea is that freedom of religion and separation of church and state are liberty rights, and the state is not allowed to deprive you of a liberty right without due process, which is to say, applying the protections of the Bill of Rights to citizens of the state. So if you ever hear anybody say, the First Amendment just says Congress shall make no law, right, and therefore it doesn't apply to me, they're wrong. And that's why. It's because of the 14th Amendment and incorporation. Okay, so that is the quick and dirty rundown of the sort of basic text of the constitutional provisions that talk about religion and government, right? So let's talk about the specific clauses, right? Our two biggies, the Free Exercise Clause and the Establishment Clause. Now, these clauses work together in tandem sometimes and sometimes in opposition to guarantee religious freedom for people in the United States. I'm going to talk about them separately, but there are a lot of concepts and a lot of overlap. And so there are some things that I might talk about under the Free Exercise Clause that would seem to apply to the Establishment Clause and vice versa. And that's not by accident, right? That is fairly normal. They interact with each other. So what rights does the Free Exercise Clause guarantee? So the First Amendment only says Congress shall make no law prohibiting the free exercise of religion, right? That's it. That's all it says. So what does that mean? Functionally, what it means is that it means that government is not allowed to place burdens on a person's religious belief or a person's religious exercise or activities to varying degrees, right? Like it's not necessarily an absolute guarantee, but it's pretty strong. So pretty much anything the government does that targets belief is going to be unconstitutional, right? Like if the government passes a law that says that you can't be a Baptist within our town limits, right? It's going to be unconstitutional, right? Because it's targeting religious belief. Religious action is a little bit different, right? Or Muslim, yes, exactly. Religious action is not always protected. The government can occasionally burden religious action if it has a compelling enough reason to do so, right? What we want to try and provide, it's keep the government out of it, basically, right? Don't have the government promoting anything. Don't have the government putting its finger on the scale. Specifically, so like what you want to think of here is that like it would be unconstitutional for the government to prohibit like Muslims from having, church services or in a town, right? You can't do that. But there are some instances in which the government can place burdens on religious action. The sort of basic example is the Supreme Court said that it was constitutional for the government to prohibit, to apply its criminal drug laws to indigenous tribes that use peyote as a sacrament, right? They use it in their religious rituals. But the government has enough of a compelling interest in enforcing those drug laws to overcome that religious interest. So the question is, how does it work? What can the government do? How can it restrict you? How can it not restrict you, right? In terms of your free exercise of religion. So there are a couple of different ways. The basic one, and it has to do with a standard announced in a case which, if you followed the Supreme Court at all last week, you may have heard of, called Employment Division versus Smith, which was in fact the case about the indigenous persons that were using peyote, and there was a criminal statute enforced against them, right? So the standard announced in that case, and I may call them standards, I may call them tests. Essentially what we mean is the sort of what we look for when we're trying to determine if there's a violation of the Free Exercise Clause, right? So the test that was announced in Employment Division v. Smith is that if a government law places an incidental burden on religious practice, is not unconstitutional if that law is, and here are the key words, neutral with regard to religion and generally applicable. So a law that is not, you can't have a law that targets religion, that would not be neutral, right? You cannot have a law that, like I said before, right? No Muslims allowed, no Baptists allowed, no Wiccans allowed, right? That is not neutral with regard to religion, right? But drug laws are neutral with regard to religion because they are not targeting religious activity. That's not their point. Their point is to target drugs that are seen by the government as harmful, right? Nothing to do with religion, but it may have the effect, as it did in this case, of burdening religious rights. And the other standard is whether it's generally applicable, which means that it applies not just narrowly to this one religious action, but to a broad section of people. So drug laws apply to everybody, right? They're not targeted at religious groups. But an example of a case where you didn't have a generally applicable statute was, there was a case, I think it was in South Carolina, a city called Hialeah. They had a large population of Santeria practitioners. One of the things Santeria practitioners do is in their religious rituals, is they have animal sacrifice. I believe they do so humanely, but the town fathers were not very comfortable with this. So they wrote a law that it basically outlawed any kind of animal butchery, but then they went through and they made exceptions for basically everything in town that involved animal butchery except for Santeria religious practices. And so when that got to the court, they said this is not a generally applicable law, because the lawmakers have made sure it only applies to this one religious group, right? So, excuse me. So that generally speaking is the standard we look for at the federal level, right? Generally at the federal level, as to whether a law is violating your right to the free exercise of your religious beliefs. Is the government placing a burden on your religious beliefs? And if it is the rule, regulation, or law neutral with regard to religion? And is it generally applicable to a bunch of different people, and it just happens to place a burden on your religion? I should back up a little bit and say, for both the free exercise clause and the establishment clause, these are restrictions and prohibitions on government action, right? Private people don't violate these provisions unless they are a government contractor or are given government authority or something along those lines, right? These are prohibitions on government. Specifically for the free exercise clause, another requirement for a free exercise violation is that the government has to be doing something coercive. And what that means is that the government has to be sort of using its authority to compel you to reject a belief that you hold, or to take an action that violates, that is against your religious beliefs, or to take an action that is, on behalf of another religious belief that you don't share. There has to be for the free exercise clause, there has to be some element of governmental coercion for there to be a violation of the clause, right? Okay, so back to Employment Division v. Smith very briefly. After Employment Division v. Smith came down, a lot of people in Congress really didn't like it. They were very angry about it. They're still angry about it. If you go to the Fulton decision from last week, you can see Justice Alito being very angry about it for about 77 pages in his concurrence. They would like it to be struck down. It hasn't yet. It's still there. So the Congress, but immediately after it came down, Congress decided that they wanted a different standard. The old standard that had been used before Employment Division v. Smith set the new bar, right? And so they passed a law called the Religious Freedom Restoration Act. The initials for it are RFRA, and you will hear people in our line of work call it RFRA. So if you hear RFRA, think Religious Freedom Restoration Act. And what the Religious Freedom Restoration Act does is it rewrites that test. It rewrites the test. And instead of neutral law of general applicability, what it says is that if the government places a substantial burden on a person's exercise of religion, then it is unconstitutional unless the government demonstrates that the burden is, one, in furtherance of a compelling governmental interest, so you have to have a really strong interest, and two, is the least restrictive means of furthering that interest, right? So you can have the strongest interest in the world for doing whatever it is that you did that burdened religious activity. But if you could have done it in a way that didn't burden religious activity, and you chose to not do that, if you chose to put the burden on people, then it's unconstitutional, right? This is a much harder standard for the government to meet. It is much more protective of religious exercise and belief, much more. RFRA was struck down by the Supreme Court. The federal RFRA was struck down by the Supreme Court as against the state and local governments, right? So why am I telling you about it, right? Well, the reason that I'm telling you about it is that after it was struck down, about more than 30 states passed their own RFRAs. I think all of the state RFRAs use basically the same framework that I just described to you, right? Substantial burden, compelling interest, least restrictive means. So if you're concerned about what a free exercise violation looks like in your state, one of the first things that you need to do is check and see if your state has a RFRA. Because if your state has a RFRA, then the rules that apply to what the state and local governments can do are going to be very different than the Employment Division v. Smith standard. Now, Smith is still going to, outside of a couple of like really weird exceptions, which we're not going to talk about because it's not worth it, is still what applies to the federal government and any state government that does not have a RFRA. But if your state has a RFRA, then that applies at the state and local level. Okay. One more statute to be aware of is a statute called the Religious Land Use and Institutionalized Persons Act. And so we don't have to say that all the time. The initials for that are RLUIPA, and we call it RLUPA, the Religious Land Use and Institutionalized Persons Act. Now, that has two different provisions. The first is the land use provision. The land use provision, the point of the land use provision of RLUPA is to prevent local governments from using their zoning laws to prevent unwanted religious groups from moving into town, right? Most commonly, you want to think about somebody wants to build a mosque, like a Muslim group wants to build a mosque, the locals freak out, and all of a sudden the zoning regulations suddenly say that that plot of land that you bought can't be rezoned for church use. You can't put in a parking lot here, right? All these little things that can be thrown up as an obstacle to doing things like building a new church or making additions to the church, adding parking, that sort of thing, right? That's what it's for. Unfortunately, we're also seeing a lot of instances in which this portion of our RLUPA is being used to bully municipalities into allowing things that really shouldn't necessarily be allowed. But so if you ever are in the position of building a church, please don't do that. But the standard for RLUPA, I should say, is exactly the same as RFRA. RLUPA is very closely related to RFRA. It uses that same substantial burden on religious exercise, compelling interest, and least restrictive means language, right? So that's the first half of RLUPA. The second half of RLUPA is the Institutionalized Persons Act. This applies to anyone that is that has had their freedom restricted by the government, meaning prisoners, right? So prisoners have a lot of their rights curtailed just as a function of them being in prison. But they still have their right to free exercise of religion. And so what the Institutionalized Persons Act portion of RLUPA does is it requires the prison, subject to some security restrictions, right? Like they can still maintain institutional security, but they really have to provide prisoners with religious opportunities for religious worship, to have religious books, to have non-security threatening religious items hats and rosaries and those sorts of things, right? Like that's what the Institutionalized Persons Act portion of RLUPA is for. Okay. Now you've got sort of the basic framework for the free exercise clause. There's only two more very related things that I want to go over really quickly before jumping to the Establishment Clause, because I'm really burning through my time here. So the first is something called the Ecclesiastical Abstention Doctrine. And this is, I think, very important for religious folks to know, right, is that this is a doctrine that is created by the courts. It's not written down anywhere. It was created by the judiciary, right? And essentially what it says, it comes out of both the free exercise and the Establishment Clause. And essentially what it says is that the courts will not hear any case. I mean, courts are for resolving disputes, but they will not resolve any dispute that is about a matter of theological doctrine, right? Like, so if you have, like, we see this a lot when you have like a sect schism off from a mainline church, and the sects have a very vehement disagreement over doctrinal things. And a lot of times that comes into play as in, like, who owns this church building, right? Like, is it the Presbyterian Synod, or this weird, offshoot of the Presbyterian Synod that has just been created, from the people that used to use the church, right? But if the resolution of that conflict can only be found by interpreting church doctrine or theology, court will not do it. They'll throw it out. They will not do that. If it can be resolved through purely non-religious matters of law, like contract, like if you have a contract that doesn't say anything about religion or doctrine or anything like that, right? The court will apply the non-religious portions of the contract. They'll do that. But there is no court in this country that will hear a dispute about theological matters. They won't do it. Closely related to that is something called the Ministerial Exception, which has become a big deal in church-state law recently, right? The Ministerial Exception is similar to the Ecclesiastical Abstention doctrine, but not quite the same thing. So the original purpose of the Ministerial Exception was to exempt churches and religious organizations from anti-discrimination laws when those churches are hiring ministers of the faith, right? And you can see the logic behind this, right? If you have a Baptist church and it's looking for a preacher, and an atheist comes in and says, "Hey, I'd like to apply to be the preacher at your Baptist church," they can say no, right? They don't have to hire that person. And I mean, if you strictly applied Title VII, you are not allowed to discriminate on the basis of religion in employment, right? And discriminating against this person because they're an atheist would be discrimination on the basis of religion. But it also doesn't make any sense to force a church to hire a non-practitioner for ministerial duties, right? Makes perfect sense. But a lot of what we're seeing right now with the use of the Ministerial Exception is that there's a lot of legal firms on the other side of this issue that are advising their clients to basically call all of their employees ministers, pretty much no matter what they actually do. We have a case that we are working on right now. We call it the Tucker case, and it's about a fellow who was a teacher at a religious school. It was a church school, but he taught science. He didn't have very many sort of religious duties. He didn't lead students in prayer or anything like that. He had adopted some Black children, right? And there was some absolutely virulent racism directed at him and his kids from students in the school and from their parents. And so at one of their sort of large convocations, he got up and he basically preached a sermon about what the Bible has to say about racism, namely that it's bad and that you shouldn't do it, right? And the school was initially like totally on board with this. They're like, yeah, that we agree wholeheartedly with what you're saying. We think this was important. Then they got leaned on by some of the aforementioned racist parents, and then they fired him. And now they're trying to claim that he was a minister and that they should be exempt from anti-discrimination laws because he was a minister. Except that our contention is that he wasn't fired because of his religious beliefs. He was fired because of his views on race, which is discrimination on the basis of race, not discrimination on the basis of religion, right? Race. So there's an example of a hot button issue that is sort of ongoing in the courts.
I have a question for you before you jump to talking about the establishment clause. And there are actually, thank you for the information. There are actually quite a few questions that are in the chat. And so I want to make sure that they get addressed.
Yeah.
And I think we lost you for a moment, but we got the idea of what you were saying.
Yeah, I got a little,
So
my connection was unstable, so
oh, okay. That's okay. It happens. I wasn't sure if it was me until David just mentioned it. So the question that Susan asked was, will you address how taxpayer money affects free exercise? And then there was another question you mentioned, RFRA. So last week, Maggie talked about RFRA, and we sent out a document to those that attended last week's session because there was the question of how many states have RFRA laws. And so we shared that 23 states have RFRA laws, but there are 22 states that have a RFRA statute. And so I'll put that information in the chat. But can you answer that question? And then also, I'm gonna give you one more question in this pause. I saw there was a question where someone asked, could discrimination be, does discrimination count as compelling interest? And they basically said it does real harm after all. So those are some of the questions that I saw so far in the chat.
So let me go, so let me answer the last one first. Does discrimination count as a compelling reason? It ought to, right? But I mean, if you saw Fulton, right, like last week, the Supreme Court issued a decision in Fulton v. City of Philadelphia, where the city had refused to work with Catholic Social Services as an adoption provider because Catholic Social Services discriminated against gay people, LGBTQ people, when certifying them in this program. And the state has the city of Philadelphia has anti-discrimination provisions. It says if you want to be an adoption provider, you can't discriminate, right? And the court basically said that the city had to work with them, right? That because the city provided, well, a scheme for exemptions, they've never actually exempted anybody from the anti-discrimination provisions, but because they had a scheme that potentially allowed for exemptions, they said that if you go back to Employment Division v. Smith, it wasn't a generally applicable law because you could have exemptions. So this is a fight. The question about compelling interest, what's a compelling interest and all that, these are the fights that are ongoing, right? And we are certainly on the side of, yes, discrimination on all the bases of Title VII ought to be a compelling interest for the government, such that it should be allowed to put some restrictions in some cases on religious activity. Not in all cases, but in some cases. So that's, I mean, yeah, good question. It's ongoing. So can you remind me again, Sabrina, what were the other two? Because we got thrown.
Oh, yes. The other question was about, can you speak to taxpayer funds? Will you address how taxpayer money affects free exercise?
Sure. So taxpayer money is often thought, it's generally more of an establishment clause issue, the question of whether the government is allowed to provide money to religious organizations. But actually, it's interesting. The founders thought of taxpayer money almost as a free exercise issue, right? They often said that the government, getting involved and provision of taxpayer money for, training of seminarians, actually, and for upkeep of churches and all these various other things that had happened, over in England and in France and in a lot of countries in Europe. They actually called that sort of thing, that sort of intermixing of government and religion, they called it blasphemy, basically. I think it was James Madison pointed out that what happens when you get that intermingling of government and religious groups through that kind of funding being one way, is that it cheapens religion, was the idea, right? The idea was that it doesn't, having the government put its thumb on the scale in that way means that the religion can't stand on its own if it needs that kind of help, and it's not attracting followers through the power of its ideas and the power of faith, but because the government is funneling people to it, right? So a lot of those ideas about funding like really do play into the point of free exercise, which is to keep religion and religious belief a matter of the private sphere, not a matter for the government to get involved in. Which, if I've answered that question appropriately, then it should lead us right into the Establishment Clause, because this is sort of the idea of the Establishment Clause. So the Establishment Clause is sort of the more controversial half of these things, I think. It is where the phrase separation of church and state comes from. If you hear lawyers talking about the Establishment Clause, they're talking about the separation of church and state, right? The prohibition on governmental establishment of religion. Now, as I was just saying right then, right, the purpose of the Establishment Clause is not to be anti-religious. That was not what it was for, right? I don't think anyone could accuse the founding fathers of being anti-religion. They had some of them had some odd views on religion, but I don't think they were anti-religion, right? And sort of the point here was that they looked at, a lot of them came from England, where there was an official state church that had changed a couple of times over the years, actually, depending on who the king was and whether he wanted to curry favor with the Pope or, with the Church of England, all that sort of thing, right? And they had some like really violent conflicts over suppression of religious sects. And I think the idea was to head that sort of thing off at the pass and to keep religious belief in a separate sphere from government. And even now, actually, if you look at modern European states with official state churches, actually, I think you actually find that the rate of, if you want to find where all the atheists are, you'll find them over there, right? Like, it actually really depresses involvement in the church and religious activity and expression, right? Because people feel that it's being pushed on them in a way that is not conducive to actually building any kind of genuine faith or faith community. So the Establishment Clause is meant to protect that by keeping the government out of it. We don't want the government, it sort of works in dual ways, right? One is the more traditional way of, you don't want the government endorsing a particular religion, right? By giving them money, by having their prayers said at government meetings, although that happens, by teaching children the doctrine of any particular religion, right? We don't want any of that. On the flip side, it also prohibits denigration of religion, right? So governmental denigration of religion is equally unconstitutional. There was a case in California where a history teacher got sued by a student because he just was relentlessly denigrating Christianity in the classroom. One of his choice quotes that I've always remembered is, "You can't think rationally when you've got your Jesus glasses on." And the court found that that was unconstitutional because he's a government agent and you can't use a government position to denigrate religion. That is the correct decision, by the way, right? So the Establishment Clause contains both of those things. It's not anti-religion. So how does the government violate the Establishment Clause? So I mentioned before that one of the ways that the only way that you can violate the Free Exercise Clause is the government is doing something coercive. That it is also true that the government violates the Establishment Clause if it is coercing religious activity, right? If the government, we often see this in parole issues where the government will require somebody who's out on parole to go to a religious, like, drug treatment program. That's unconstitutional. The government cannot force someone to go or to stay away from church against their will. That's unconstitutional under the Establishment Clause. The government can't, like, force you to profess belief, right, in any particular doctrine. It can't force you to do any of those kinds of things. So coercion is one way to violate the Establishment Clause, similar to the Free Exercise Clause. But unlike the Free Exercise Clause, coercion is not necessary for a violation of the Establishment Clause. It is enough, but even if the government is not coercing belief, it can still violate the Establishment Clause. Now, how does that work? So the basic test, until the Supreme Court sends it to a farm upstate, is called the Lemon Test. And the Lemon Test has what we call 3 prongs. And if the state violates any one of the 3 prongs, then whatever law is being challenged is unconstitutional. So those 3 prongs are that if the government takes an action that has the intent of endorsing religion, it's unconstitutional, right? So if the government passes a law with the specific intention of encouraging church service, church attendance, or, Muslim worship, right? Or, whatever, that's unconstitutional. But the second prong is that the law or policy has the effect of endorsing religion. And that is, again, that's independent of intent. We write a lot of letters to people and they'll say, we never meant to endorse religion, which means we didn't endorse religion. That's not how it works, right? If what you did actually, in practice, has the effect of endorsing religion, then it's unconstitutional, right? The third prong is called the Entanglement Prong. It's if the government is entangled with the operations of the church or vice versa, then you get it also unconstitutional. That one's not used very much. Often the endorsement prong and the entanglement prong in court cases are sort of combined together into something that Justice O'Connor used to call the endorsement test. An example of entanglement would be if the government gives out liquor licenses, but they allow a local church to have a veto over who gets a liquor license. That sort of thing happens actually quite a lot. That's unconstitutional entanglement between the government and the church. The government can't sort of cede governmental authority or decision-making to religious authorities. And then finally, and then we'll get to questions. I know I've flown through this in particular, but the last thing is what is very likely to replace Lemon if and when the Supreme Court gets around to finally doing away with it, which, I mean, they've been sort of hinting around it for a long time. They haven't done it yet, but it's a test that doesn't have any official name. It originally came up in the line of cases that has to do with prayers before legislative meetings, like meetings of Congress, your local town councils and stuff like that. Called legislative prayer. And the test there is what we call the history and tradition test, which is basically where the court looks at whether a particular practice, even if it has religious stuff in it, if there's a history of doing it or a tradition of doing it, then they're very likely to want to say that it's constitutional. This has only been applied in the situation of prayers before legislative body meetings and with long-standing monuments. So there's a case with a giant cross on government property that had been there for 90 years. The Supreme Court let it stand. They said that it had been there for long enough that it had become sort of traditional and lost its religious meaning and sort of that sort of thing, right? If all of that sounds very kind of dismissive and cursory, it's because it is. Like, if I could give you like a rational explanation for how that's supposed to work and make any sense at all, I would, but I can't because it doesn't make any sense to me. But it might be where we're going with the Establishment Clause. But as I said, we're not there yet. Right now, the way you want to think about the Establishment Clause is, are you being coerced into doing something? Or you think about the Lemon factors, right? Is there an intent to endorse religion? Is there an effect of endorsing religion? Or is the state being sort of entangled with the church? Okay, there.
Wow, thank you, Ian. that it's a lot to digest, and we've had this conversation ahead of this conversation today. And so one of the things I'm going to do is share in the chat is that Americans United, we have a lot of resources on our website in terms of information, things that you can read. There is a section on our website under issues. It's about government support of religion. And so when Ian was just talking about displays and even talking about official prayer, and also taxpayer funding of religion. So I'm gonna share that in the chat with people as a resource, and hopefully that will lead you to some of the other pages that we have where you can read information.
If I could, and I just want to say, we have a reported violation form on our website as well, right? And all of those, anything you submit through the reported violation form is, one, confidential, right? And two, basically it comes directly to me. So if you ever have a situation where you think that there might be a problem, send it in, right? I am more than happy to look at it. I know people worry about like wasting my time or whatever, right? Like they think, oh, this is a silly question, and they get nervous about asking it or anything like that. There are no silly questions, right? If you're not a lawyer, then I don't expect you to know any of this stuff, right? I'm more than happy to look at it. And even I'll tell you a secret, most lawyers don't actually know this stuff, right? This is not like this. Actually, most lawyers would never even learn in law school unless they actually actively sought it out. So there's no shame in not knowing this stuff. And part of what AU does is to educate people. So if you have a question, if you come across something you think is questionable, ask, please.
Thank you. David, do you see any questions in the chat? And for if you give me a moment, I do want to share the screen so you all can see that this is, if you go to the website, if you're on the main AU webpage, this is what you see. But at the top, you click on report a violation, and you can go there and put in information. As Ian said, he will contact you if you submit a violation, but or a report of a violation, I should say. So there is the question. We want to ask. I have to scroll up. Okay, Susan asked the question. There are two Susans. So Susan A asked the question, can you give Amy Coney Barrett's interpretation as well as your own regarding, in her Fulton concurrent opinion, she seemed to say that religious institutions should get special privileges.
Yeah, so Coney Barrett, her concurrence there was interesting in that she seemed, so all of the conservative justices' discussion in Fulton was about, fundamentally was about whether we should get rid of Employment Division v. Smith, which we talked about earlier, right? They want to get rid of it. The difference between Alito, Gorsuch, and Thomas, and Coney Barrett and Kavanaugh is the question of what would happen, like, is it time to do that, right? And so Coney Barrett was essentially going through and saying, well, I don't really like Employment Division v. Smith, but she thinks that like just getting rid of it, like whole cloth, would cause a bunch of problems, right? Like a bunch of litigation, a bunch of questions that they would have to answer. And she's worried about that. So she joined with the majority to craft a fairly narrow opinion that doesn't get rid of Smith, right? My personal opinion of Smith is that it is a good decision. Odd for me to say because it was written by Justice Scalia, but like as a workable standard, it's very straightforward. It's easy to apply. Everybody knows how it works, right? And I don't think it's particularly over-inclusive. Like I don't think it overly suppresses religious activity, but my view isn't the one that counts, unfortunately.
Okay, there's another question here. Does the intent to endorse religion have to be to endorse a specific religion, or can it be to endorse just religion in general?
Good question.
Susan Lee.
Yep, good question. Just religion in general, right? So the standard is that the sort of inartful way that one Supreme Court decision puts it is that the government is not allowed to endorse a religion over religion or religion over non-religion, right? So the answer is you can't say religion is awesome, atheists are bad, right? Atheism actually, by the way, has all of the protections of the Free Exercise Clause because it is seen as a viewpoint about religion and thus is considered technically a religion for the purposes of free exercise protections and those sorts of things. But so yeah, just religion in general can get you in trouble under the Establishment Clause.
Okay, and Gloria asked the question, after Greece, would AU still be willing to pursue the prayer before government meetings issue?
So yes, but we're very limited by Greece. Like we are very limited by Greece. So essentially what you have to have after Greece is you have to have a pattern of either clear discrimination in selection of prayer givers, right? So a clear pattern that they are absolutely unwilling to have, like a particular religion. We've actually done some work on this with, legislatures that have refused to allow atheists to speak right? So yeah, that would be of interest. And then the other way is if there is a clear pattern of the prayer being used to denigrate other religions or to proselytize, to encourage the listeners to convert. Now, when I say a pattern of that, I really mean a pattern of that, like a long-standing pattern of it. One instance of it's probably not good enough, unfortunately, even though it's really horrific when it happens. The other thing is when the legislators themselves are giving the prayer. We're very willing to look into that as well, because there's some language in Greece that suggests that that would not be permissible. It's the sort of thing that we might be willing to pursue on. But those are some very narrow circumstances. But if you have a question, like I said, if you have a question, absolutely feel free to ask it, and we will look into it.
Great, thank you, Ian. And this will be the last question. Thank you, Michelle. Would followers of beliefs like QAnon receive religious protections? If not, what is the qualifying factor to make something a religion?
Okay, so interesting question. So the thing about religion is that the definition that the law uses is very expansive. Like the free exercise clause protects lots of stuff that most people would consider bizarre, right? Like the only real, so it needs to sort of be, QAnon probably not, because it needs to sort of be related to the question of these sort of base religious questions. Where do we come from? Is there a deity? These sorts of things, right? So like any old belief is not necessarily going to qualify as religion, not necessarily. But the government technically is not actually allowed to determine whether something's a religion or not a religion. The only thing that they're allowed to decide is whether your stated belief is sincerely held. So this sort of comes up it came up a lot in the 60s with people that requested religious draft exemptions. And so the resolution of those cases turned on, if you had a conscientious objector who was claiming that their religion didn't allow them to serve in the military, right? And the basic thing that the court wanted to determine was, is this person just saying this to get out of the draft, or do they really have a belief in nonviolence that stems from a religious place, right? And again, the court is not allowed to tell you that whatever you believe, no matter how bizarre, is real or not, right? Like a lot of times, like you actually, I have a concern about this, because you see a lot of politicians talking about how Islam is not actually a religion, that it's some sort of political movement, right? Like you see people say stuff like that. Like the government's not allowed to make that determination, right? The only thing they can decide is whether or not you're sincere. And so like if whatever it is that you're asking for with regard to the government, some sort of exemption, like an accommodation, that sort of thing, is if it stems from a belief that is traditionally sort of in the religious realm, it's probably going to get a lot of protection, or at least a very serious look.
Well, thank you so much, Ian, and thank you to everyone that asked questions from today's presentation. If you have more questions, I encourage you to email us. You can email me, and we'll get those questions to Ian, as well as, or David, if you want to send the information to David. I know some of you use our Basecamp system to communicate, and so that's wonderful. So again, thank you, Ian, so much for sharing with us today. Thank you for all of you for coming to today's session. I hope that you will join us next week for our final summer AU Summer Series, when we talk about next steps and becoming an advocate. Each week we've built the information onto the next week in terms of the steps that we could take into becoming an advocate for religious freedom for church-state issues. And so next week our presentation will be by Sarah Gillooly, who is the VP of Outreach and Engagement. So we're excited excited about that. And I will share the resources page with you all again for those that weren't at last week's meeting. But again, thank you. And I hope that you have a great rest of the week. Take care.